All right. Very good afternoon, ladies and gentlemen, joining us from across East Africa. It's a wonderful Tuesday afternoon, wherever you're joining us from, and we are thrilled and privileged to have you at this very wonderful session that is discussing a subject that is on the rise. Recently, there's been a debate or discussion on uh, deep fakes using AI to concoct evidence. We've seen allegations oftentimes being made by state attorneys or state prosecutors on against different accused persons. And some of these evidences have come to be proved to be AI generated. And as such, this afternoon, we are having this interesting conversation on AI in criminal investigations. And we are discussing the implications for defense, evidence, and justice. And on behalf of the Secretariat, we are really glad to host all of you with us this afternoon. And thank you for joining us wherever you are joining us from. Please feel free to post in the chat box wherever you're joining us from so that we are able to connect and have a very wonderful afternoon. Now, this afternoon, friends, we have quite a very distinguished panel, and our distinguished panel comprises of esteemed ladies and gentlemen that have crafted a niche around the area of criminal law, AI, and criminal investigations. But we also have tech experts and tech gurus, since we're talking about artificial intelligence, to come into this room and shed more light on how these trends are evolving. And in no particular order, please allow me to introduce our panel with our uh, speakers, starting with Mr. Lawrence Dinga. Mr. Lawrence Dinga is a seasoned consultant with a wealth of experience and expertise in cybersecurity, digital forensic, cybercrime investigations, and cyber capacity building. He holds a Master of Science degree in forensic computing and security from the University of Derby in England. He has an LLM in ICT law from the Open University of Tanzania and a diploma in law from the Kenya School of Law, as well as a certified information systems security professional. Now, Lawrence is a digital forensic expert witness and has testified in many cyber-related cases. Currently, he's an international consultant with various organizations. The list is very long if I start mentioning them. I will mention them until the cows come home. But Lawrence, it's very wonderful afternoon and very good to have you on this session. Maybe you could just turn your camera on and say a quick hello to our participants. You're on mute. Lawrence, you're muted. We didn't hear that. But,
yeah, thank you, Gabriel, for that introduction. And I hope that this conversation is going to go well and everybody is going to benefit from it. Thank you.
Thank you so much. And probably you'll also tell us the intersection and the interest from your portfolio. You have a master's in science and then you have an LLM in law. Maybe you later on in the course of your discussion give us the genesis of that as well, so that you could inspire some of us to venture beyond our portfolios. But it's a pleasure to have you on. Our next speaker is Ms. Janet Othero. Ms. Othero is a legal and regulatory expert specializing in cybersecurity, data protection, fintech, and regulatory technologies. She advises clients on the legal implications of cybersecurity incidents, cyber resilience strategies, and the broader regulatory and operational impacts of digital risk. She has developed deep expertise in fintech regulation, payment systems, RegTech frameworks, and data privacy governance, supporting financial institutions, technology companies, startups, and government entities across complex digital and regulatory environments. Now, she has over 7 years experience and widely recognized for her contribution to banking, finance, and capital markets regulation, and was ranked as a next generation lawyer in banking, finance, capital markets in the Legal 500. That was way back in 2018 and 2019. But currently, Janet is our chairperson of the Data Protection Committee of the East Africa Law Society, but she's also founder and managing partner at Coventry's. Janet, it's a very lovely afternoon and it's a pleasure to host you once again. Anytime there's a talk on tech, you're the go-to person on tech, but good afternoon and good to see you. Maybe a quick hello from you.
Good afternoon, Gabriel. Good afternoon, my co-panelists. I'm happy to be here to further a discussion on an area that I have only mostly seen on TV. So it will be very interesting to see what the experts in that area have to tell us, and also to see what the advocates who are attending today will share their experiences in terms of just criminal procedures. So happy to be here, Gabriel. Thank you.
Thank you, Janet, and thank you for accepting to be part of this exploration. Looking forward to a wonderful discussion. And moving on to our next speaker is a brother and a friend, Mr. Abubakar Sekanjako. Abubakar is a legal practitioner with a Master of Law degree and an LLB degree from Makerere University, a postgraduate diploma in legal practice from the Law Development Center, and a postgraduate diploma in public administration and management. He is a member of the Uganda Law Council and has served on the governing council of the Uganda Management Institute. His practice spans corporate and commercial law, litigation, land law, and constitutional matters, with involvement in landmark cases and policy shaping legal work. He has prior experience in private practice and at the Parliament of Uganda, and has participated in several international and legal policy frameworks, including election observation missions and global innovations and climate diplomacy programs. Abubakar, it's very wonderful to have you. Good afternoon to you. And we are quite honored to have you on this session and love the mix that you're bringing in from private practice, but also having worked at Parliament and also on this arm of litigation where you're currently litigating on a very interesting case in Uganda. But Becca, a quick hello from you. And yeah.
Good afternoon to you, Gabriel, and good afternoon to you, my fellow panelists, for this afternoon session. And good afternoon to all the advocates and other interested parties and stakeholders in the audience. I'm glad to be here. Thank you so much.
Thank you so much, Becca. It's very wonderful to have you this afternoon. Our next speaker, friends, is Mr. Turiamusima Geoffrey. Now, Mr. Turiamusima Geoffrey is a man who is known to us all, but allow me to introduce him briefly. He's an advocate of the High Court of Uganda. He has a Bachelor of Laws degree, and he has a Master of Laws degree from Makerere University. He is currently a member of the Uganda Law Society and has been recognized as a leading constitutional and human rights lawyer, including being named Human Rights Defender of 2021 and Rising Star of the Year 2021 by the Uganda Law Society. He also bagged an award for being the best criminal law litigant by the Uganda Law Society, and he has been widely regarded for his advocacy in constitutional litigation and his work in defending fundamental rights and constitutionalism. In Uganda, Mr. Turiamusima is also managing partner at Kratos Advocates. Mr. Turiamusima, it's a very wonderful honor to host you this afternoon, and thank you for making time for us. A quick hello from you, and hope you're doing well.
Oh yes, I'm doing well, and I am so humbled to be part of this team. I'm glad, and thank you so much, Gabriel, and everyone. I'm excited to be here. I'm excited to be part of this panel.
Thank you so much, Mr. Turiamusima. We are also glad to have you. And of course, to introduce our moderator, our good friend and chairperson of Young Lawyers Committee, Ms. Brenda Imelda Mukoka, who also works at the Office of the Director of Public Prosecutions in Kenya. Quite interesting, Brenda, to have you this afternoon, and in particular, to have you moderate a session where you, who are on the prosecution side, are being accused of trumping up charges and using AI to, prefer charges on different people. But it's an honor to have you and looking forward to a very wonderful conversation. I would now like to hand it over to you to take us through the segment. To all our participants joining us both on Zoom and both on our YouTube channel, you are very, very welcome. And we look forward to a very wonderful conversation with you all. Brenda, it's over to you now. Thank you.
Thank you, Gabriel. Thank you for that introduction. Good afternoon, everyone. Yes, my name is Brenda. I'll be the moderator of this session this afternoon. I can see it's already 2:15, so I will allow our panelists to give their presentations. Then we can engage as they give their presentations. You're welcome to send in your questions that you may have. I'll also be sure to ask some follow-up questions so that the discussion can be interactive on both ends. So first up, I think we'll have Mr. Mwalimu Lawrence Dinga to give his presentation. So Mwalimu, you're welcome.
Thank you very much, Brenda, for the opportunity. I have a small presentation that I want to present here. Let me just share my screen. I hope everybody can see my screen.
Yes, I can. I think I believe everyone can see it. Yeah.
So I have a brief presentation that will invoke some questions from the participants. But what I'm going to talk about is the AI investigative tools and accuracy. That is the technologies transforming criminal investigation. Now, let me just hide this. Okay. We know I'm not an expert in AI, but as a cybersecurity guy, we encounter these issues of AI everywhere. And now everybody knows that AI is something that we cannot ignore. You've had many organizations now laying out guys like developers and opting for AI for those kind of jobs. But as pertaining to investigation, we know that AI can actually enhance investigation, but also raises important legal questions. That is, it raises questions about fair trials and rights, because when you do investigation using AI tools, is the party really will actually get fair trials. We are also looking at evidentiary reliability. How reliable is the evidence that is produced using AI tools? Is how reliable is it to stand the threshold of the legal threshold? And then the accountability. Who is accountable? If something goes wrong, is it the police? Is it the software, the developer itself? Is it the government? And the due process of when you are presenting evidence in the court of law, was the due process followed? So these are some of the questions that important legal questions that we need to ask ourselves. Now, if we look at applications in AI application investigation in criminal investigation, we talk about predictive policing. It is good because algorithms can analyze historical data to predict potential crime locations and suspect. However, predictive policing can also lead to discriminatory outcomes if the historical data set that it depends on contains bias against certain communities. We can also look at AI in facial recognition and surveillance. I mean, this is something, when we talk about smart city programs, this is something that have been implemented in many cities across East Africa. So we find that we can use AI-powered cameras and biometric systems to identify suspects from images and video surveillance. That is something that if you look at in Nairobi here, it is implemented using Safaricom and Huawei, and we can see the AI-powered cameras everywhere when along our streets. And the only thing is that there's also legal implications when it comes to facial recognition and surveillance, because one, there's the issue of privacy implications. And mass surveillance. And at the same time, as much as we are implementing these technologies, we know that the law is moving slower than technology. So there's lack of regulatory oversight when we are looking at this, when we are looking at these technologies. Now, when we look at digital forensics and data analysis and analytics, AI can always help investigators process massive amounts of digital data, which includes emails, phone records, social media, financial transaction. And this is relevant when you are investigating things like cybercrime, when you are investigating financial frauds and organized crime. So we find that AI is a tool that is useful. What are some of the legal implications in criminal defense when you're using AI? One thing is that the right to fair trial, that I talked about that. Now, the use of AI may challenge fundamental fair trial principles. That is, so when somebody is presenting AI tools, the AI-based evidence, then what should the defense ask? How is the AI system work? That tool that you're using to produce the evidence, how does it work? Whether the algorithm that is used in that AI, is it biased? And can the output be independently verified? These are things that when we look at the way digital evidence is presented in court of law, which is backed by many, most of our evidence law, these are some fundamental questions that you need to ask. Then there's also another thing when it comes to access to algorithm and data. Many AI tools are proprietary. So you'll find that they are owned by private organizations. And when they are presented, the evidence is presented based on AI tools, then the defense teams may not be able to access the algorithm. And when they're not able to access the algorithm, then courts may rely on evidence that cannot be fully examined. This is what we sometimes we call black box or opaque, because the defense cannot be able to verify the authenticity or reliability of that AI-based evidence. So this undermines the principle of equality of arms, which requires that each and every party should be accessible to all the information that is used as evidence. So this is one of the areas that also we need to look at. Now, when it comes to admissibility of evidence, traditionally, the courts will base their evidence on relevance. Well, how is that evidence relevant to the issue or the case that is presented? The reliability. can the process that was used to derive that evidence, can it be, is it reliable? Can the court verify that whatever the process that was used to generate that evidence, is it reliable, and can it be verified? Now, the other thing is authenticity. Is that evidence that is produced before the court using AI tools, is it authentic? Is that evidence proves what it proves to be? That is the authenticity. And this is something that when you present your evidence in the court of law, these are questions that always either the prosecution or the defense will always ask. What is the chain of custody? From the time the evidence was collected to the time the evidence is introduced in the presented in the court of law, is the chain of custody intact? Is it been broken? So these are some of the things that when you're using AI generated evidence, you need to ensure that they are taken into consideration. But AI-generated evidence also introduces new challenges. When we talk about reliability, when we talk about transparency, courts must determine whether AI introduces scientifically reliable outputs. You remember when you're talking about forensic evidence, we are talking about scientifically proven outputs. So is the AI able to present, the system must be able to produce scientifically reliable outputs. So lack of transparency in algorithm may complicate this process. And this is what I talked about when I talked about opaque systems, or we talk about AI tools that cannot be verified, because you need to have access and you need to know how that works. And this is what I call black box. When it comes to still an admissibility, we are talking about authenticity and integrity of data. We know that AI always rely on large data sets. So if the underlying data that is presented in the court of law can be manipulated, or it was obtained unlawfully, or it violates data protection laws, because I know East African countries have implemented data protection law. Now, if it can be manipulated, if it can be obtained unlawfully, it can violate data protection law, then that evidence may not be admissible in the court of law. Then right now we know what about when we talk about deep fakes and synthetic evidence. I mean, if you talk about Kenyans, I think the Gen Zs have shown us that you can be able to produce fabricated videos, you can be able to produce manipulated images, you can be able to produce synthetic voice recordings. So these are some of the fundamental questions that we need to ask when we are presenting AI-generated evidence. Again, when we look at AI, what is the impact on justice and human rights? Now, we talk about privacy and data protection. So AI surveillance system collect large volumes of personal data. In East Africa, this include concerns include lack of data governance frameworks, weak oversight of law enforcement technology, and potential misuse of surveillance data. So that's some of the impact on justice and human rights that we need to look at when we are introducing AI generated evidence in our cases in court of law. Now, accountability and liability. If an AI system leads to a wrongful arrest and conviction, what are some of the critical questions that you should ask? Who is responsible? Is it the police? Is it the software developer, the AI software developer, or is it the government? So those are some of the human rights that we need, fundamental that we need to look at. Now, some of the challenges and policy, regulatory and policy challenges in East Africa, when we look at AI, we find that we have outdated law. Most of the laws address electronic or digital evidence, but not AI-generated evidence. So you'll find that when you look at the laws like the Evidence Act in Kenya, we can look at Section 106B. It shows, it tells you how you should present electronic evidence in court, but it is not, it's silent on AI-generated evidence. Then also we look at the expertise. Courts and legal practitioners may lack the expertise to evaluate AI systems. What about oversight? Weak oversight frameworks. There's limited regulatory governing AI use by law enforcement. Sometimes where you can use this and it can be challenged in court because there's no legal basis or there's no legal framework that is supporting that evidence in the court of law. Then we talk about, when we talk about cybercrime, we know that cybercrime is something that goes beyond the borders. It does not respect any geographical boundary. So when you are using AI investigation, you must, it involves international data flows and digital platform. That can be also very difficult when it comes to cross-border investigation. Now, what are some of the policy recommendations when we are talking about AI-generated evidence? We talk about the governments should be able to develop AI-specific legal framework that we are actually lacking now. Where most of the laws that we have in East Africa, evidence law, they are talking about electronic evidence, but not AI evidence. So governments should create legislation that are addressing AI evidence, algorithm accountability. How is that algorithm that is used in that system? How is it work? How can you, is there accountability? If it is opaque, then we cannot be able to rely on that. Then we also need to also address law enforcement use of AI. Is the law enforcement are allowed to use AI in their investigation? Because if they use AI and there's no legislation that is actually supporting that, then it becomes a problem when that evidence is presented in the court of law. So also this should be, the government should work on the establishment of transparency in requirements. AI should use investigation must meet standards. And these standards are also something that we need to define or to develop. Explainability. When you are introducing AI based evidence, you need to explain to the court how the system works. You need to tell the court what are some of the error rates of this system. Because if you don't do that, then it becomes an opaque. Auditability. How can you be able to reproduce that evidence if there's need for by either the prosecution side or by the defense side? What is the auditability? And this auditability is something very important, even if you look at some of the principles when it talks about forensic evidence or electronic evidence. Auditability is very important. And this is one of the cases that we witnessed in 2014, which was, I think, delivered by Justice Aggrey Muchelule, was about the gubernatorial election and which was contested by I'm forgetting the name, against the other. The issue of auditability came in because what Agri Mchelule said is that you need to produce that track so that when the other party also contests the evidence, then you should be able to reproduce that evidence. Now, that auditability is very important. And so we need to make sure that AI system used in investigation must meet the standard for auditability. Also, independent verification, so that whatever the other party will be able to verify that this evidence is actually what it says it is. Then we also need to look at strengthening the data protection laws, because AI investigation must comply with the national data protection frameworks, which I think 3 East African countries have developed. So some of the key technologies that you can are used in smart cities, that like in Nairobi we have the smart city programs, which was implemented by Huawei and Safaricom. So we have the AI-powered surveillance, which have got CCTV with facial recognition. In Kenya also, we've seen automatic number plate recognition and also real-time monitoring. So these are actually being used in criminal investigation to track a suspect across locations. And we've seen in Kenya when some of these guys have been assassinated, they use this the CCTV cameras and facial recognition to do the investigation. Also, they can be used to identify individuals in the crowds, and also it can be used to reconstruct crime scenes. And Nairobi is a good example where we see that Nairobi projects are linked to the Nairobi urban security upgrades. Now, the other thing is integrated command and control centers, that these are centralized systems that will centralize police data, emergency response, traffic monitoring, and intelligence feeds. So they allow law enforcement to respond quickly and coordinate investigation in real times. Now, I want to just give one case study, one case law that we can also use. I had quite a number, but because of time. Now, if we look at Republic versus Mark Lloyd Stevenson, the issue was admissibility of evidence, that was emails and digital records in a criminal case. Now, the court held that electronic evidence need to be admissible only if they can be properly authenticated. So the prosecutor must, in a case where you need authentication of the digital evidence, then the prosecution must prove the integrity of the system that produced that evidence and the reliability of that data that is used for evidence. So what is the relevance to AI in this case? We look at that. It establishes the foundation for admitting AI-generated evidence in the court of law. They must, if you are introducing that evidence, then you must prove the algorithm, the reliability of that algorithm. You must prove it in court. And that is why what I talked about, explainability, how the system works. What are the error rates of the system? That needs to come out very clear for that evidence to be admitted in the court of law. We also talk about chain of data processing. We are talking about, in traditional investigation, we are talking about chain of custody. From the time the data was collected, the evidence was collected, the evidence was preserved, and the evidence is presented in the court of law. Can you be able to establish that when you're using AI-related tools to produce evidence? I think that is the end of my presentation for now. Thank you so much.
Thank you so much, Mwalimu.
Back to Imelda.
Yes, thank you so much. I think we've all learned a thing or two So maybe I can just ask you one question before we proceed. Do you think our law enforcement officers are adequately trained to interpret this AI-generated outputs, from your opinion?
Brenda, we have issues in that area, but I think I've worked very closely with the cyber department in the DCI, and I can see there's a very big improvement when it comes to forensic investigation. However, this is an area, when it comes to AI, it is an area that is gray, is something that is new, and I can't say that we are well equipped, but I think we have very capable guys in at the DCI right now who can be able to do this. I can't hear you, Brenda.
Sorry, I'm saying thank you for the presentation. We have Mr. Peter Angubwa is asking if you could share a copy of your presentation. So maybe you can share with the ELS Secretariat, and then I think they can disseminate the same to us via email. Yes, but thank you for that, Mwalimu.
I'll do that.
Okay, thank you. Our next presenter is Mr. Abubakar Sekanjako. I think he'll be taking us through admissibility, reliability, and the weight of AI-generated evidence. So you're welcome.
Thank you so much, our listeners and followers. And I thank Mr. Dinga Lawrence for the powerful presentation that he has just made. I hope I got the name right. And I'm basically going to...
Yeah.
Yes, so thank you so much, and for setting the tone of this discussion. And I thank you for the extensive research that you made in this particular aspect of the discussion. Of course, artificial intelligence, in its sense also, it's a new area that we are still grappling with to appreciate. You see, from my reading in preparation of this particular session, of course, drawing from the aspects of practice that I have interacted with in regard to AI, even the rule of law itself, it's a growing aspect that we haven't yet settled with, especially on this continent and especially in this side of the Africa, where issues of what is the law, of what should be the norm, of what should be the standard, we are still grappling with those questions. And then you now bring in a new dimension, which is growing on a daily basis, which is growing on, it's quite amorphous. It's hard to even define. Because to understand AI, you have to first get a definition of what is AI. But you'll find that from different authors, there has not been a common decision that has been settled, especially from the legal perspective. The question of what is AI, it is still perturbing the legal minds here and there. But there has been a definition which I would draw the listeners their attention to, that that at least it is gaining the force of law in regards to regulation. It is a definition that is in the recommendation of the Council on Artificial Intelligence, which is under the OECD, and that definition, at least, it puts in context. It brings out the key issues that you look out for when you're talking about AI. Of course, it's machine learning approaches, the logic and knowledge-based approaches, then the statistical approaches. Of course, it encompasses a number of things, but for them, when you look at that definition, you'll find them it's broad, and I do not want to bore you. But again, different authors have come out to say that well, there are quite a number of definitions. And now that brings out the context of what the black box that the previous speaker has been referring to in his presentation. The black box. What do they mean by the black box? Because in his presentation, he has indicated that there are a number of issues that inhibit the too much reliance on AI. Of course, you can rely on AI in your investigations as a litigator. I mean, it enables you address a number of things in record time, effectively and efficiently, without wasting a lot of time. You can get an answer. You can get an investigative report on a situation. But now the question of the black box, what is the black box system? The black box, it is the fact that you don't know who is giving you this information. It is a system that you feed in the information, but underneath that system, there are layers of neurons, like the way we have them in brain, that keep feeding the output and the input. That you feed in the question, then in record time you get the answer. That you're investigating someone, you want to pick the record. There are records. Let's say that you're looking at facial recognition. In microseconds, it has recognized that the person who is attempting to access this system is so and so. So the question that is perturbing the jurists at the moment is what is happening underneath this black box? How is this system able to interpret this particular person? How is the system able to give an opinion on a situation? And now that takes me to the question of the day that I am supposed to handle. Basically, the black box and the question of which kind of evidence should the AI be categorized as. Of course, it is still not a settled debate again, whether it should be regarded as documentary evidence or whether it should be handled as an expert evidence. Of course, these are things that you'll find in day-to-day litigation. We interact with them. But again, works of scholars has greatly influenced my research in preparation for this debate. Because in most cases for litigation, the way it is at the moment, we haven't interacted so much with AI, and especially in our court systems. These are some of the things that are still coming on board. For instance, when you look at the ICMIS in Uganda, the electronic case management system, it has not been tested. And when you look at the way the court looks at it, it's as if it's you cannot actually argue. If it is a notification that you're supposed to receive, you find hard time to prove to court that you didn't receive that notification. Because for them, they believe that their system cannot make a fault. That if you're to receive a notice, a hearing notice, they take it that the system prompted that notice to you. So in that regard, should we carry the ECMI system as a documentary evidence or an expert opinion that counsel indeed received the hearing notice? So those are some of the questions, because if you fail to categorize it, if you fail to classify it, you find hard time to put it in the context of the Evidence Act that we have today. My colleague has just mentioned that our laws are not yet brought to speed with the current, trends with the AI to incorporate fully AI. When you look at the AI, the Evidence Act of Uganda, which was drafted in 1900s, you're not going to find anything mentioned like AI, and there hasn't been any effort to amend that law to bring it to speed. So that's why, as a practitioner, you'd be pushed to at least have it admitted, depending on who is presenting it. You can have it admitted as a documentary evidence, because we have seen in courts, in commercial court, where emails are relied upon, let's say, to prove service, to prove contract executed, to prove that maybe even a WhatsApp communication can form a valid contract. Under such circumstances, you find that for you to rely on a WhatsApp conversation, you're not going to just bring a gadget. You're required again to have that information extracted from the gadget and again brought, as a form of documentary evidence. And of course, there are situations where you find that this evidence per se has been thrown out. Of course, for failure to prove, let's say in the case of Uganda versus Dr. Sorry, I had indicated it somewhere. Okay, I'll go back to it. Where the evidence was thrown out, whereby it was there was failure to prove the jurisdiction in which the phone that posted something on the post, a Facebook post, was recorded, was based, because the question of jurisdiction is very important. So you have such questions, you're grappling with such questions, and now you're faced again with the classification. Should it be expert opinion, or should it be to the expert opinion? Expert opinion. In this case, who is the expert? Who is the expert behind the AI? So that's another question that has not been addressed, because where some of the AI platforms that we have commonly used, they draw from different sources. So it is hard to know which expert really influenced or informed the decision that now this AI system is giving you. And there have been cases, of course, this particular aspect has been litigated in the US, like I would indicate in the case later on, in the Compass case, one of the cases that has had a very rich discussion on AI, the Compass case. The question of who has influenced the decision put out in the system has been pertinent, and it is still standing as we adopt this AI evidence and support in criminal investigation and criminal practice. And now the other aspect that I wanted to talk about, or that I am supposed to talk about, is the question of the black box. Like I mentioned, the black box, some authors have looked at it in about 4 dimensions, and I'll mention them. In the dimension of the data-driven science, because when you look at AI, it is basically data already stored somewhere, that is recycled, that is, examined to give a particular answer to a given situation. So yet questions of law are factual. Today, someone might have committed a crime or committed an offense, and tomorrow their mind would be, a very different one in regard to that particular situation. Let's say traffic offense, that today I committed it, but then it is not guaranteed that tomorrow I would commit the same crime, but maybe today I was rushing to court. So it is not a usual thing that all the time I will keep committing that particular crime. So this system is going to indicate that since there are multiple situations, or since I've been recorded as a person who has flouted the processes in regard to the traffic regulations, then the data is going to score me as an offender. So every time my face pops up, it's going to flag me as an offender. So it is data driven, which indicates that it might be biased at some point against some people, or even failure to read faces, to recognize faces. It might fail to recognize a particular face, and you would not easily know, because these are systems that you're dealing with. And there have not been so many, opportunities, a lot of opportunities to at least address some of these challenges. So the question of data, like my colleague even indicated earlier, that sometimes even the who collects data matters, because this is data that is already collected and stored somewhere. And this data, you don't know who collected it and for what purpose. Let's say for the AI that people commonly use on the media today, the ChatGPT, that if you ask a question, it is going to pick from different articles in Uganda. But now the question is who is writing, who is posting on social media, on the media and of course on the internet. Do you have all the information about Uganda on the internet today? You realize that some of the information is not there. And then for this system, it's going to pick information and the output would be, you know, as drawn from the data provided to it. So you may end up with biased information. And of course, this leads to discrimination in some point because of the illegitimate data. And now the other aspect of the black box is about the complexity of data in itself, of technology. In that the language of the internet, if you are to go to the dashboard, if you're to look at the way the systems work, at the way the information is interpreted, if you type in today something in your computer or on the system, of course, the specialists are going to tell you that the model, the way it interprets information, it is 010101. So how are you going to interpret that information on the back end? Let's say if you're cross-examining someone who is providing you this information, that when you typed in a particular segment of a trial, that let's say this person is going to take a plea. Now record that plea and give us information, whether, you know, a particular aspect, whether he's telling the truth or not. So the system is going to give you the answer that the person is telling the truth, but you'll not be able to interpret the specific language, the model, and all that was put in place to ensure that you get all that information. Yet for human intelligence, you will be able to cross-examine someone on why they believe someone was telling the truth or not to court. So there is that lack of clarity on the way information is processed and on the output itself, because the backyard of the system is not what we see. And if you to look there, if you to go and examine what is happening there, whatever you're going to see will not even understand. They are going to be X, Y, Q, what, 001, 001. So you'll not be able to interpret that information, at least to the required burden and standard, which is the proof beyond reasonable doubt. So if you have that burden of proving beyond reasonable doubt, that standard, how are you going to be able to do that if you're relying on information interpreted by a system and the system cannot clearly indicate what language and how it managed to evaluate that information. The other aspect is about the fact that this opacity, or this black box has been created by the law, whereby how has the law created this? Is that well, the different authors have indicated. For instance, there is this Dr. Greenstein Stanley, who has indicated that this black box has been created by the law, whereby the intellectual property of the formulators or the people who invent these systems, the intellectual property is protected. So you're pushing for them to give you the transparency and accurate information about their systems. But the business is that they are supposed to retain some trade secrets about how their systems work. And that's how they are going to earn, to keep earning. And in some of the information that they would give you, it might even endanger the system itself. Some people might hack it and it fail to work. So you find that the intellectual property and trade secrets are taking precedence over transparency. So you're unable to get the full information about a particular system and how it operates. Because even if you get a witness on the stand and you start questioning them, how they manage to reach at a particular conclusion, they would reach a stage and tell you that for that particular segment, my system is protected. I cannot give you that information. So you'd end up having no clear answers about a particular report that was generated about regarding your client and maybe the question at hand. So the case that I wanted to share with us that created at least a standard, which most of other cases have been, relying upon and taking consideration of. It is State versus Loomis. It's a US case where they used the system called the Correctional Offender Management Profiling for alternative sanctions. So in this particular case, a sentence was determined by the risk assessment system. So in that, the system could interpret the face of the offender, then they project that maybe in the future.
Yes, we had lost you for a minute there. I wanted you to repeat the case that you're referring to, and also to remind you that your time is up. So kindly share the full citation, then you can wrap up. Thank you.
Hello?
Hello, can you hear me?
Yes, I can hear you, but I heard you were cutting me short.
No, yes, I was saying you can share the full citation of the case.
Full citation of the case.
Yes, because we had lost you, and then also you can wrap up with your presentation because, yes.
No, this is the last bit. This is the last bit.
Okay.
Yeah, so in this particular case, it's State versus Loomis. I think I'll post it in the comment section. It's State versus Loomis, LOOMIS. It is the citation is WISCTAP, September 2017. Sorry, 17th of September 2015. You close the brackets, 2015 WL 1724741. It's a United States decision. That's why maybe the citation is like that. It's not the way it's not among it's not like the citations we are used to. In this particular case, they set a standard. In this particular case, the witness, the accused was sentenced, and they were basing the sentence on the findings of that particular system that I just mentioned, the COMPASS system. So the COMPASS system could project that in the future, someone would offend again, or that given the particular, manner in which the offense had been committed, it determines and predicts the punishment that should be imposed. So this was contested, and it went up to the Supreme Court. So the Supreme Court upheld the decision that was based on the system. And it held that so long as the system has been explained, so long as you have explained how the procedures that you went through as the system developer and the operator, and indicated that maybe this is how I feed in the information, and this is how it determines the punishment to be imposed, then there is no problem. That was the decision, that it does not, again, flout your right to a fair hearing or fair judgment. And they just put the qualifier, that the qualifier should be that you do not rely on the system, but you take into consideration the report of the system. So the system's autonomy should not override the human control. That is what some authors have created as the principle of human control. That you, as the judicial officer or as the practitioner, you should not just get the report from AI and take it as the gospel and final truth. You still have the autonomy, the human control and autonomy to observe, to contemplate, to weigh. You have to be independent and fully assess how and the context in which this report should be used in a particular situation. So that is the benefit. So that's what we can benefit from this case, that it introduced that principle of the meaningful human control. That in however much there is this system that is going to support you as you investigate the case, but you should not lose focus that this is going to be your report. The signature on this final output is yours, but not the system's signature. So finally, the other issues that we should warn ourselves about regarding this technology and why it's considered a black box. Of course, there are situations where you are likely to face or to get wrong results arising from miscodings, arising from error, the technical errors, scientific errors, or legal errors. Because like I mentioned, where you have various articles on, let's say, on the media, and then this system is going to be drawing from that particular source. So it's going to rely on information that, let's say, in skewed data, that the information provided has a legal challenge. So the system is going to base itself on that. It's going to base its decision on that information that is skewed in a way, and it gives you a wrong information. So as I conclude, and as we still grapple with this question of the artificial intelligence in our criminal processes and investigations, we should, as practitioners, as enforcers, and as judicial officers, always warn ourselves and be clear that this information we are just relying on, we are just considering it. We are not relying on it fully. We should remain in control of how it operates and how it assists the criminal investigations and the criminal proceedings. Thank you so much.
Thank you, Mr. Abubakar. We will now move on to Ms. Janet Otero. Ms. Janet, if you can hear me.
Yes, I can hear you, Brenda.
Okay, thank you. Let's also try and keep the presentation to at least 10 minutes. So we have time. Okay, thank you.
So I'll try and keep it very brief, so as not to repeat what my other speakers have said, but also to just give way for more interactive discussion. I was covering the data privacy or the privacy issues that may arise from police investigation, police surveillance, and also we were looking at what is the existing regional framework and what would probably hinder chances of interregional support or interregional compliance when leveraging on AI for criminal surveillance and investigation. So like you've been taken through by Lawrence and Abubakar on some of the ways in which AI can be used. In a normal investigation scene, you see a situation where investigation scenes are just meant to aid the law enforcement agencies when they're putting together their cases for prosecution. So you're looking at securing of the crime scene in terms of collecting any evidence that may be there. And this may be physical crime scene or maybe a digital crime scene, as we've seen in the past in terms of hacking, unauthorized access to systems. But also we are looking at a situation of a physical crime scene where an actual physical crime has happened. We're looking at how they conduct witness interviews. We're looking at how the evidence is collected and, like Lawrence said, chain of custody with how this evidence is collected and kept. We are looking at interrogation. What are the interrogation methods they use? How do they leverage on technology to carry out interrogation? How they do their final reporting and putting together the case file for a final prosecution. And these are all instances where we are seeing a situation where it is data being collected, it is personal data being collected at a minimum, and it's a whole lot of moving data sets that are being collected, especially when you decide to leverage on technology for all these actions. So, I mean, the standard protocol and the standard practice when it comes to investigation is to document everything, collect everything and document it, because the end game is to present it as evidence in court. But as you're doing this, you're also looking at the rights and the rights that are guaranteed to these suspects, or the rights that some of these witnesses or victims of this crime are entitled to under the various existing legal regime. One thing to remember is that whatever technological infrastructure or technological advantage that we'll be using is to facilitate or to basically give a competitive edge to existing legal regulatory framework and existing guidelines or existing codes of conduct that have been there in the place. So what we're doing is we're just deploying and leveraging technology on a higher scale to be able to comply or to be able to assist us to comply with these existing procedures or legal regime. So as they're doing that, we, like Lawrence said, we'll be using technology and AI specifically in this instance to be able to just help us analyze data, analyze evidence, especially dealing with an economic crime that has several documents that you're looking at and need to be analyzed in real time to be able to come to observe the pattern of criminal activity there. Then AI can definitely be helpful when it comes to analyzing these documents and picking up certain patterns. You're looking at digitizing case reporting. Kenyan courts are fully digital. A lot of evidence is being exchanged on digital platforms, save for some hearings. But you're looking at a situation where a case file is able to move from one division or one agency to another in a very secure manner in real time, and also analyzed and marked for prosecution in real time. With regards to surveillance, you're able to just identify suspects, identify weaponry, and identify anything that has been used to commit or to perpetuate a crime. You're looking at forensic analysis in a way that we have probably suffered before, because looking at the past of various cases that have been handled. When it comes to the forensic analysis, this may take time because dedicated labs are not at capacity or the best capacity. So leveraging on AI may actually be able to just fast track how forensic analysis is done, either on physical or digital evidence, as it were. Then you're looking at, like Lawrence said, predictive policing, where is a situation you're identifying hotspots of criminal intention before they happen. Again, this can, we've seen, for example, during gatherings and rallies, but you can also use it for arson, you can also use it for sexual offenses, to be able to just provide a profile of where you feel like this area needs to be covered more. But also in terms of just analyzing fake evidence and also being able to do away with fake evidence, that's something that AI should be able to assist or has been able to assist. And as we are doing this, and also remember we are doing surveillance, how it was done or how it has been manually done is surveillance has just been a dedicated officer physically or in a car following a pattern or a criminal pattern or criminals to identify suspects or to be able to just protect witnesses. So when you're looking at surveillance where we've decided to leverage on technology, where you are able to send a person, probably like we've seen in movies, on top of a roof with disguise in a car, you're now looking at deploying things such as drone, which are able to hover over a location for some time. And we've seen this with the war that's ongoing on in Iran and in US and in other countries, where they've been able to collect intelligence and they've been able to do surveillance using drone. And the next frontier in terms of just police effectiveness and also military precision is on the amount of data sets that you're able to collect and analyze within certain parameters for you to be able to provide better policing services or to gain a military edge. So what happens once surveillance is done? When surveillance is done, the data is collected and it is analyzed. From a military perspective, a command would be issued based on these surveillance reports for the next course of action to be done, even from a military advantage. But what you're saying is, while the old method involved waiting for officers to come from the ground, type out a report, submit pictures, take it up the chain of command for the chain of command to meet and discuss and give a directive in a couple of days, this is able to be done in real time, where the drone collects the information in real time, takes it to the headquarters or the strategic rooms, and where a decision is also able to be made in real time based on information collected. So looking at that as the way in which investigations, surveillance are being carried out currently or will be carried out in the next few years, then what are some of the data privacy principles that we must think about when we are doing this? Again, principles such as lawfulness or transparency, where you are able to inform and to tell people that as a state organ, as an investigative authority, this is why we are undertaking this, and this is the lawful basis we are relying on, and this is the transparency within which we are operating this particular tool or this particular technology. We're also looking at a situation of accuracy, like you've been told before. Bias and hallucination and prejudicial results are very common with AI tools. So you should be able to put in place controls that give out very accurate results, because remember, when you're dealing with criminal procedures, you are dealing with somebody's life, either as the person who's been aggrieved or the person who's to be a suspect. You're also looking at minimization. This has been discussed in terms of what amount of data that you're able to collect and keep and use for your processes. You're also looking at what would consider accountability. How are we getting oversight for some of these enforcement security? Who's developing it for them? Is the data staying here locally, or is the data being exported out of the country? Considering these are very sensitive areas, is the data accessible to the executive bodies or the state organs where this data is being exported? Does it have a disadvantage to us as a country in terms of our military strategy or our policing strategy? Then also we have to look at the data subject rights in terms of their rights to be able to know and give a consent and opt in or opt out of these very drastic technological advancements. For example, large-scale surveillance, as has been discussed. Is it something that the citizens of Nairobi know? Has it been informed to them properly that large-scale surveillance happens within these areas and these perimeters? Have they been informed it's for crime deterrence? Once this data is collected, is it only for that purpose, or do the state agencies now purport to use it for other reasons, such as profiling, for instance? So those are the questions that probably we need to ask ourselves and discuss further. Then, having looked at those areas in terms of just putting mitigation measures and ring fencing the use of AI, both Lawrence and Abubakar have spoken about them. But one I'd like to emphasize on is what we call the human in the loop. This is just ensuring that for any analytics that's being done, for any deployment and for any use of any AI tools or products, there must be a human exercising a level of intervention, a level of oversight, a level of review for any final results or any final output that's being given from these tools. And this is also in line with the most of the data protection acts that say for any automated processes, there must be a human at the end of these, especially where the results are meant to prejudice any natural person. And we've already discussed how AI has the potential of creating bias and prejudicing people. Apart from that, Lawrence talked about training some of these models. The challenge we have is we rely a lot on international vendors for some of these products based on the successes we've seen there, but also just based on the fact that they have capacity to be able to develop these products. So as we are customizing them for our benefit regionally, are we looking at where we stand? What's the code of conduct for the Kenya police, for the Uganda police, for the Tanzania police, for the Rwanda police, for the South Sudan police? What's their code of conduct? What's their culture? What is their mission? How have they been driven in terms of investigative procedures? And then looking at this tool and deploying this tool, is it integrating fully? Is it able to adopt how they've been doing the operations? Or are there issues that are presenting a bit of a conflict or a clash, such that they're now foregoing what it is they consider is their ethos and their culture to be able to use this tool to undertake the operations just because it's been bought, it's there, and it has to be utilized? So those are some of the questions. Then also in terms of transparency, which has been discussed, I cannot overemphasize enough the need to have an audit trail or transparency into how some of these models are used, the data that is collected, and where this data will eventually sit if outside the country. And then having a governance and enforcement mechanism. Various countries have already launched or released AI policies, AI strategies, but we do not have a country within the East African region that has its own standalone AI law. I also think it's not yet time to have a standalone piece of legislation on AI, given how it is always evolving. So I think that's a conversation that can come later. But in the absence of a law, there are already existing legal framework that govern the use of personal data, that govern police conduct, that govern how infrastructure is outsourced and procured. So looking at all that, it only becomes necessary to come up with very sector-specific guidelines or a code of conduct. If we are looking at the state agencies or law enforcement agencies, what code of conduct or guidelines can we give them when it comes to leveraging on this? If we are looking at financial sector, will theirs be different or similar? If we are looking at manufacturing sector, will theirs be similar or different? So coming up with very sector-specific parameters, guardrails, or guidelines should be able to help keep some of this in check. But also, what is the who has oversight of whether these individuals are complying with what has been set for them or they are not? Are we willing to give oversight to Parliament? Are we willing to give sight to existing bodies such as police oversight authorities? Are we willing to give oversight to law societies and civil society to just be able to have a say and an insight into how some of these tools are being deployed by state agencies? Then finally, as has been a conversation before, data crime might be it's very jurisdictional, internal and external. It may cross borders from time to time, which requires a level of cooperation between different agencies from different countries, regionally and globally. So again, the challenges we face is just capacity-wise. We may not be at the same level. Infrastructure-wise, we may not be at the same level. While some of this data is collected electronically on one end, the other country may not have the capacity, so they'll be relying to use this data in a very manual version and remit it or relay it back in a very manual version. And this can cause a bit of friction, or the standards of security of exporting this data might be compromised.
Janet, can you hear me?
So we are looking at a situation where, even though we have an African Union Convention. Hello, Brenda?
Yes, we had lost you for a minute there. Okay, you can continue.
Sorry. So this becomes very hard in terms of just cooperation. There are some jurisdictions that have done what we call adequacy decisions, where they say because we have all achieved a level of compliance over the years, then at this level, we can exchange data freely. This is not the case for Africa because we did enact the laws and our infrastructures are different. So we are hoping that in the future, even if it is going to be very sector-specific sort of data governance frameworks to allow for exchange of data, then this will be welcome. So in conclusion, I would say that compliance and enforcement still remains a challenge, even for manual investigation, even for manual cooperation. From a technological perspective or a digital perspective, hopefully this will change. Hopefully countries around the region will be able to leverage on seamless technology that is very secure and that they're able to exchange criminal data or surveillance data back and forth, but also to be able to just build capacity in terms of training, benchmarking policies, and just exchanging knowledge and idea. Again, security operations should not be scared of adopting and using AI. I feel like it's the future. I know it is the future. I know it will make work easier. I know it will be able to catch criminals, or it will be able to arrest criminal situations that were not able to be arrested by manual procedures. And hopefully what we can do now is just to build guardrails around how security agencies are able to deploy and use these tools to their benefit and for the benefit of all. So we'll stop there, Brenda, and give the next speaker a chance. And I will answer Gilbert's question.
Okay, you answer it on the chat, or you want to answer it now?
I will answer it in the chat.
Okay, thank you. Next we have Mr. Geoffrey, who is going to speak to us on defense rights and algorithms. I'm so tired.
No, you're not tired. We're not alone. That word is hard.
It is, but yeah.
All right. I'm glad to be here. And Geoffrey Tuliamsima, Managing Partner of Kratos Advocates, formerly 1 Million Company Advocates. I am pleased to also build on the insightful discussion of my colleagues, the former or the previous speakers. And I will take on the discussion a step further, but basically or mainly on the defense perspective. And my focus is on the defense rights and that word, algorithm. Hopefully everyone is at par with me. Thank you so much. Okay. We should understand that at its core, the discussion or today's discussion is basically not only about technology, but it's also about justice. And this is because AI increasingly finds its way in East African criminal justice or investigations. The question, however, is no longer whether AI will be used, but whether it is, the question, however, is not whether AI will be used, but whether its use will remain consistent with the constitutional guarantees which we do protect as defense counsels. Traditionally, we all know that criminal defense has relied simply on principles. But one of the powerful principles is every piece of evidence must be capable of being challenged. But AI comes in to disrupt that foundation. With one, evidence generated through complex processes or methodologies. Two, processes that are not easily explainable. And this we have found it more, especially for us who do international crimes, terrorism, trafficking in children or in persons, and all that. Then another important aspect or confrontation is the systems that may not be accessible to the defense counsel. Now, all this creates a fundamental imbalance between the rights of the suspects vis-a-vis the rights of the victims. Now, the defense counsel must therefore be able to treat each evidence critically by demanding full disclosure of how it was generated, questioning its reliability. The good thing my earlier presenters or speakers talked about this, especially Mwalimu, and seeking independent verification. Where the disclosure is insufficient, admissibility should be contested. Then what could be the biggest challenge, especially for us on the defense team? The biggest challenge should be that every piece of evidence, however small it is, must be challengeable. And if the same is not done, then there is a problem somewhere. What could be the best strategy? The best strategy is for all the defense counsels or defense team to refuse to accept AI evidence at face value. AI cannot be determined, cannot be based on face value. Someone has to go deep beyond what is on that report. Why am I saying so? Because AI output is not truth. It is the product of data inputs, methodology designs, human configurations, and each of those elements is open to challenge. Therefore, what is practical is that the defense counsel must demand, like I said, full disclosure of all the evidence generated, question the reliability and limitations of the system, insist on independent verification where possible. Why? Because undisclosed processes cannot produce reliable evidence. There is an important aspect of access to all this. to the audit trails or even access to source codes. The prosecution authorities or the prosecuting authorities mainly rely on tools like discussed by Mwalimu earlier on. But all these tools are confidential. The source codes are protected and the system is too complex to disclose. However, what must be very clear is confidentiality cannot override constitutional rights in all other regions or in all our regions. For instance, if an accused person is not meaningfully challenging evidence, they may have a challenge in accessing all the evidence. Hopefully we are together.
Yes,
What
we
is
are.
the effect? Perfect, right. Thank you, Brenda. What is the, we have now the element of effective cross-examination of expert witnesses. Remember, AI evidence is oftenly produced through expert witnesses, either from police forensics or even independent forensic reports from different known experts. And this is where the defense team or the defense must particularly be strategic. And the goal is not attacking the witness who has brought it, but also to expose the limitations of the system. And the key areas of cross-examination most times include the expert's understanding of the tool. Do they really understand how it works? Or they are just relying on the report, which is the output? The errors or the error rates of the system. What is the margin of the error? And another important aspect is the validation. Has the tool been tested independently? Has it been tested anywhere? Or it is only being used especially for this case? And all other more. Now it becomes more clear that the expert is not explaining the system, but merely reporting what has been produced. Now we have seen, especially with police forensics or the expert forensics who come from different statutory organs, mainly not all of them are well versed with the AI. The same thing with the defense. But what is important is someone just reporting what was produced, or the defense team or the defense will be able to examine them, to cross-examine them, especially on their understanding of the tool, and thereafter getting the errors out of the system. What are the safeguards therefore, especially in regards to the due process and fair trial or fair hearing? The discussion here can only turn to the first principles. Why? Because a right to fair hearing is non negotiable. It includes the right to know the case against your client. It includes the right to challenge that evidence which has been brought. And indeed, it includes the right to equality of arms. AI must not erode those guarantees. However, court must also be vigilant to remain and ensure that technology does not in any way create evidential shortcomes. What should be the call of all of us, not only the defense, but also the prosecution together with the court? As members of the legal profession, we have a shared responsibility. One, as the defense counsel, must adopt and develop the skills to challenge AI in all ways. And on this note, I would take this opportunity to appreciate the East African Law Society. Many years ago, they organized a session for us with Mwalimu in Kampala. And I think the same thing can be done in all other regions. And now there is a call for young lawyers in Uganda, which is very, very encouraging. The second one is the prosecution must ensure transparency, because it is key, and fairness on how such evidence is presented in court. Another important aspect, and which I think is one of the challenges we found in our court systems, that even the judicial officers, most of them, if not 90%, are not well versed with all this. Their role is to just receive whatever has been presented in court, and then they make a decision. Now, there is need for also judicial officers to exercise careful scrutiny before admitting or relying on any evidence that has been brought. And lastly, it is the obligation of all of us to interrogate AI today so that we risk institutionalizing injustice tomorrow. It is our obligation. As I conclude, it is also very important to note that justice must be seen, understood, and challenged by all parties, not only the defense, but by all parties, including court, and must be done equally. Thank you so much, Brenda. We shall be open to all questions and we see how we move forward, especially in the interest of time.
Thank you so much, Geoffrey. I think we have our last presenter, Mr. Raymond. I don't want to butcher your surname, so I'll allow you to pronounce your surname. Mr. Raymond joined us a bit late. He is a Ugandan lawyer with a passion for keeping the digital world fair and safe. Raymond's journey exploring the exciting world where law and tech meet has been largely influenced by the need for strong rules and to keep the internet secure. Today, Raymond is at the heart of shaping Africa's tech future, contributing to the AI Preferences Working Group of the Internet Engineering Task Force, the AI and Information Integrity Working Group for the Global Coalition on Tech Justice. Also the Africa AI and Privacy Working Group, the Digital Transformation Committee of the Uganda Law Society, as well as the Technology, Media, and Telecommunications Committee of the ELS. He has served as the team lead at the Center for AI and Ethics Governance in Africa, where he was at the forefront of ensuring AI is developed, deployed, and used responsibly. As the youngest ever advisory council member for the African Data Governance Hub, he acted as a trusted advisor on data governance and helping to create rules that protect personal information on the continent. I could go on and on, but Raymond is also a member of the Uganda Law Society, the ELS, PALU, an affiliate member of the African Privacy Lawyers Association, and he wears so many hats. So welcome, Mr. Raymond. You can take us through your presentation. Karibu-san.
Yes, good afternoon, colleagues, and I bring greetings from Abidjan, Ivory Coast, where we are attending the Digital Rights Inclusion Forum, and I think that's why the moderator said I was joining in on the call late. I know colleagues have shared passionately and very widely about much of the topics we had, but this afternoon I would like to speak about ethics, governance, as well as policy recommendations on how we can use AI in criminal investigations. So basically, I'll give a practitioner's perspective, as someone who has been doing a little bit of work in this space. So I want to start with something that might seem obvious, but of course, this keeps me awake at night. In a previous webinar on using AI in criminal justice, we were discussing the issue of there being a reason why we invented courts in the first place. Colleagues have already discussed what artificial intelligence is, but for those of you who do not know what it is, it's just a grab bag of technologies that are supposed to mimic what we as humans are capable of doing. You have data plus compute to give you AI. So data is the data that we have everywhere, and then computational resources is what we are classifying as compute to give us what we have as AI. We have subsets for that: machine learning, deep learning, generative AI, and all of them use data. Some use big data, others use massive data. How they work: have data, feed it into an algorithm, develop a model, and then add new data into the model to have an answer. So that is called inference. And these are some concepts or core concepts that we as lawyers should grasp, but in the interest of time, I'll skip this. So we all know that we have courts. As people on this call, of course, we're all lawyers, and we didn't create adversarial proceedings, rules of evidence and the right to challenge witnesses because we enjoyed the complexity of doing this. We created them because getting a conviction right is harder than getting a conviction wrong. And a human judge sitting in Nabilatuk or maybe in Arua making a bad call, you may appeal it. A human detective following a hunch, you could cross-examine them, as Councillor Tuyam Sima was saying, cross-examining some of these people. But what happens when you have a machine that says, my face is 99.9% a match for the person you are looking for? Or what happens when you have an algorithm that flags someone on social media or digital evidence that surfaces from some online platform that no one fully understands? So our entire legal system suddenly feels like it's standing on sand, and I would like to say quicksand. So I just want to explore with everyone today the question that isn't really, should we use AI in criminal justice and investigations? You know, that ship is far gone. The real question we should be looking at is, how do we actually use it without abandoning the principles that make justice legitimate? And of course, that's not just a philosophical question, it's a deeply practical one. Because I've seen what happens when we don't ask what this question is. So let me be clear, and I would just want to be clear on this. AI isn't just facial recognition. It's everywhere. I mean, look at open source intelligence, which is OSINT. You have a number of algorithms that are analyzing publicly available data from social media, from news sites, from public records. They are tracking patterns, but they're also identifying connections. Then you have social media intelligence, where you have AI detecting behavior patterns, but also identifying suspects from digital footprints. Some of you, when we Google your names, there is all this information that is there, and that constitutes your digital footprint. But also the way you interact, your activity on social media, what you do, etc., can also constitute what we look at under your digital footprint. Predictive policing has already been discussed. I wouldn't want to go into that, but most importantly, the issue of digital forensics, extracting, analyzing, and correlating data from devices. Devices could include phones, devices could include computers, but you could also have cloud accounts for some of us who are storing things in the cloud. Often these happen without some people knowing. Then the issue of online evidence trails, where you have evidence that surfaces maybe on this platform, but gets shared on another platform, gets indexed by search engines like Google. And once it's online, it's often there permanently. As we know, there's a famous adage that the internet never forgets. And at every stage, algorithms are involved in extraction analysis, but also correlation as well as flagging. I've already shown you the slide on data and compute. So this is part of the data that they would actually, that they actually handle. So once this digital evidence goes online, it can remain permanently, as I've seen. But we also know that algorithmic handling introduces issues like bias. I know these have already been talked about. Abu Bakr was talking about the issue of bias, the issue of errors. But we also have issues around misinterpretation at most of these single stages. And they also affect how we deal with what we have. So the real problem is four-pronged. We are deploying AI systems that are opaque. We don't understand why they make certain decisions. You had Councillor Abu Bakr use the word the black box. Understanding what the black box is around transparency is a critical issue. that we are seeing. We also have the issue of importation of designs from contexts and populations in the global north who develop, because the truth is that in Africa, we are really struggling with developing, whether it's because we lack infrastructure and resources or because we are actually not interested in using this. But these are technologies that we still use in our criminal justice system from day to day. We also have the issue of these systems being accountable to no one. In my last slide, you'll see a quote from IBM. Around 1979, IBM had a mantra that since machines cannot be held accountable, machines should not make management decisions. For the purposes of this discussion, I would like to put the word management in brackets so that we think about them as these machines shouldn't make decisions because we can't hold them accountable. The person they are going to hold accountable is the person using the machine. In earlier discussions on professional negligence, we saw some of these discussions. So if a machine cannot be held accountable, I mean, you're not going to take my phone and hold it accountable for identifying X, Y, Z or doing this and that. But you could take this other person for that. Then the other thing, I've had Council William Sima talk about the officers not knowing how to use AI. I entirely agree. Some of these systems are faster than our legal systems. They don't work on a linear scale. They move upwards. And some of our laws, the computer misuse and all the other laws that we have are laws that are maybe a decade old, a few years old, but laws that didn't have the reasonable foresight of AI revolutionizing the way we practice law as lawyers. This is a case study about facial recognition realities, and it's a case study from 2015 where we had issues of using a facial recognition system to identify a suspect. I know some of these have already been touched, so I'll not delve so much into them. But something I would like to talk about is the burden of certainty. And for the burden of certainty, I'm looking at the foundational principles of criminal law as we understand them. We have a principle that you're innocent until proven guilty. I know other jurisdictions have decided to deviate from that and do their own thing. You're guilty until proven innocent, but the founding fathers of our legal systems, as we have them, whether imported or the ones we had here, you have to at least make a case and make sure that someone was proven guilty before you could do anything. So this principle is something that comes from centuries and centuries of experience. Watching what happens when you flip the burden around. Now, I want you to think about what happens when we introduce AI that claims to be objective. We don't have a century of experience than that, or with the technologies yet. And we understand that human nature being what it is, we do tend to trust numbers. If you have a slide and you have statistics, it's very unlikely that people will argue with you because we do not argue and we like to tend to trust numbers. Now, when you have a system saying with 95% reasonable certainty and confidence, our brains are conditioned here that this is certainty, this is the truth, and we can go with it. But algorithmic confidence isn't the same as what I would call probative value. Expedit Kaya's former students in evidence law, wherever he taught, for those of us who are from Uganda, remember this, the issue of probative value. Can an algorithm be confident, consistent, systemically right, especially if it's trained on populations or data from populations or contexts that are different from the ones it's being used in? Trained in the global north, thousands and thousands of miles away in Silicon Valley, but deployed for us here in Uganda, in Tanzania, in Kenya, in Rwanda, and wherever else to use. So my first recommendation flows directly from this. courts should treat what we see as algorithmic confidence with deep skepticism and not merely difference. And I'm not being anti-technological when I say this. I really love technology, the intersection of law and technology, but I'm trying to be pro justice. On the transparency issue, we've already had a lot. But precisely why transparency matters most for us as lawyers is that if you're going to use algorithmic evidence, the legal system needs to require, and when I say require, I don't mean request. We had the issue of usually, but not always. So I don't mean request, I mean require that certain information is disclosed early and clearly. One, how was the system trained? What data went into it? What faces, what crimes, what context? Most importantly, for those of us who are on the call, was it trained on East African populations? Or was it trained on Western databases? Two, how does it actually work? And here we're not looking at marketing lingo, but actually the mechanics of how this works. Are we up to speed with it? Three, what are the known error rates for this technology? Four, what system limitations exist? Every tool has system limitations. In physics class, they used to tell us that no machine is 100% efficient. If an engine was 100% efficient, it would be flying. Every tool has them. So if a company won't name some of them, you have your answer. For the governance frameworks on how we can build some of these, something that frustrates me about AI regulation debate is that we keep talking about governance, about frameworks. In February, we were in New Delhi, India at the AI Impact Summit discussing some of these things. Even here in Abidjan at the Digital Rights Inclusion Forum, these are some of the things that are coming up. But these are being discussed in abstract terms. What does this actually mean in practice? Okay. Let's give a concrete model, for example. In Kenya, let's say financial institutions have to comply with the central bank's regulations. Those regulations didn't emerge overnight, okay? They were built based on decades, and I mean decades of experience, watching what happens when you don't have rules. And for those of you who are interested in cybercrime, something you could look at. So we need the same for AI in criminal investigations, but most importantly, in criminal justice. Now, what a functional governance framework looks like, first is pre-deployment vetting, okay? Technology has already been developed somewhere. Now you are intent on deploying it. So you have a pre-deployment evaluation. Let's say a police agency wants to use AI for investigations. You could have an independent body, not a judicial commission, but something that is specialized for tech to assess the needs, to assess how this works, not to blocking from innovation, information flow, but to ask clear questions so that we validate some of this before we roll it out. Secondly, we need ongoing monitoring. I've talked about pre-deployment vetting, but we also need post-deployment evaluation, and this is where the monitoring comes in. It's not enough to vet something once and say this works and then move away. You need to track real-world performance of some of these technologies. See how it's working here, see how it's working in this field, see how it's working in the other field. That is something that would be important. The third is on accountability mechanisms, and I'm sure this has been discussed. But most importantly, in the spirit of oneness, umoja, as East Africans, we need regional coordination, okay? And here is why I want to be ambitious. East Africa doesn't have to follow global trends. We can be the region that sets some of these global trends, especially while using AI in our criminal justice systems. Our current position, of course, we have limited AI governance frameworks in criminal justice. We have increasing deployment of imported systems without local validation, legal frameworks designed before algorithmic evidence emerged. We've had discussions around synthetic content, on this score, and also the growing capability, but without intentional oversight. We risk operating blindly, just like someone flying blindly, but the opportunity is that we could design systems intentionally as a region. And I added something on the slide that East Africa is at a critical juncture. We can still shape how technology develops in our region. We still have this opportunity. Now, for leadership opportunities, Afrocentric governance, of course, doesn't mean that we need to be different from the West. For the sake of it, it means that we need to design and protect. We need the design of these products before you can bring product liability suits to protect African populations. And this should be rooted in some of the principles that we believe in, African legal traditions, philosophical underpinnings like Ubuntu, etc., etc. Transparency first should be something that we look at. Well, we require full disclosure of training data. I don't want to go into digital colonialism where we have training data mined from African communities taken to the West to develop technologies, but the communities suffer the harms instead and get no benefit from their data being taken. Full disclosure of training data, methodologies and error rates, as I had earlier talked about. Specifically, if we can be able to center on how systems perform on East African populations. Fairness and equity is a very, very, very foundational and fundamental principle for us. We have accountability, regional harmonization, where we have shared standards across East Africa that strengthen continental integration. For those interested in regional integration, I know it has been very, very, very hard to achieve the regional integration parity that we intended to have when we had the EAC treaty. But each step that we make is a step in the right direction, even when it comes to standards for technologies and so on and so forth. So the problem with existing evidence laws, and I want to be direct about this, most evidence law in East African jurisdiction wasn't written with AI in mind. I know colleagues here have said it, but I would also like to take this opportunity to say it again. Consider, for example, a typical framework. Evidence is admissible if it's relevant, reliable, and not unfairly prejudicial, depending on which jurisdiction you are from around Africa Mashariki. But that test works okay for fingerprints, it works for witness testimonies. When it comes to AI, those tests now do break. The tests can't hold, the tests are not as strong as they used to be. So relevance isn't the problem. If the system says a fingerprint matches, that's clearly relevant, but relevance plus the black box issue colleague Abubakar was talking about, then disturbs the conclusion as to whether this is reliable or not. And I know reliability is hard to prove for those of you who are actively practicing, because a forensic method is tested in controlled conditions, you know that. But an AI system is something that is trained on millions and millions of images, millions of data, and doesn't have clean test cases currently. Of course, we keep ideating and putting our heads together to have some of these tests around these. But we can see how far we can, take it. And I believe, as I come to a conclusion, that evidence law needs a specific kind of provision for algorithmic evidence. One, not because algorithms are inherently worse, but they are different enough to require different rules. Different technologies requiring different, and I'm not asking for special treatment, but let's just have different rules. That provision should require, for example, documentation of training data and methodology, disclosure, expert testimony, specifically addressing algorithmic limitations. And some of these are things that have been discussed before. So for practical steps that exist for Defense Council, and I know the speaker before me mentioned this, colleague Tulia Musima, challenging some of these pieces of evidences early, where I use pretrial motions to demand disclosure, demanding data, for example, on error rates, things I've been talking about on the previous slide. Court should appoint expert witnesses if defendants cannot afford, but we also know the issues of cost and then the politics around the whole administration of justice, especially when it comes to allocation of budgetary votes for the ministry. Will there be enough to hire expert witnesses every time AI evidence or defense counsel requires to rely on evidence that has been generated by AI? So that is an interdisciplinary discussion that can always be had another day. Building records across cases for appellate courts, that is tracking patterns. Then appeals for novel issues, and having appellate courts more willing to engage on these issues is something that we could look at. So personally, I believe that justice must be available, not just possible. And this is where the talk gets real. All of these recommendations around transparency, around expertise, around challenges, these assume something we don't have everywhere. They assume that we have resources. But if a defendant cannot afford a lawyer, they definitely can't afford an AI expert. It goes back to the questions of the budgetary vote. If a jurisdiction can't afford a special commission to sit and see how we roll this out, then how will they vet certain systems? But here is what I don't think the answer is. So we just accept opaque systems because the alternative is hard? I don't think so. Instead, I think that what we can do is have our answer imbued, okay, in more creative and more ambitious agendas for ourselves as criminal practitioners or people dealing with criminal justice in East Africa. First, we could have regional AI justice clinics, and these, I mean, not every jurisdiction has the expertise to challenge algorithmic evidence. But once you have a regional hub that is staffed with AI experts, you have legal scholars, technical specialists, let's say from like Uganda, Tanzania, and Kenya, then public defenders in all these countries could tap into that expertise, into that hub's expertise. Second, law schools need to teach some of these things, okay? And I'm glad there is a colleague, Paul Muchibi, in Uganda, who's working on a curriculum for law schools to start integrating some of these things. I've been talking to law students in different universities, but most have never heard of the term algorithmic bias, but they use ChatGPT every day. And this needs to change, okay? Not everyone becomes an AI expert, but everyone should at least have an understanding of what these systems do and they do not do. Thirdly, judicial training, we need to boost and build the capacity of judicial officers. At the end of the day, they decide. We don't have a jury system in Uganda, for example. So you're not going to leave this question up to the jury. It's going to be a question for the judicial officers. Mutual recognition, and then maybe something else is around international support. It's something that we could also focus on, especially if we want to share resources. So I have a few humble recommendations to all on the call. We need an independent body, okay, that doesn't just lead in tech, but it focuses on that leads with judicial tech and civil society participation. Then we could have quarterly regional coordination meetings, for this independent body that I'm calling the AI and Justice Authority, but it's something we could discuss on and on. Then harmonizing regional standards is also something that is key. Binding guidelines on algorithmic evidence, not just persuasive guidelines. For those of us involved in multilateralism and those in cyber diplomacy, we understand that it is very hard to get binding instruments where all parties have consensus ad idem on what is actually being put in this. Then algorithmic discovery rights, regional expert networks, etc., etc., etc. As I conclude, I would like to talk about set sort of like an ambition that is a direction for us. Let's not just react to problems as they emerge. I mean, we're now sitting here discussing because we are reacting. Let's anticipate some of these issues, build governance frameworks that are robust, invest in expertise. Investment in expertise is the most important. And I paint a picture, an imagination, just like Chinua Achebe would do in his writings. Imagine if, East Africa became known for genuine transparency in algorithmic evidence, courts that understand what they are using, justice that works for the poorest, most importantly, the most vulnerable, as well as Afrocentric standards that protect African populations globally. This is the mantra, 1979 from the IBM: a computer can never be held accountable, therefore a computer must never make a management decision. Thank you so much for your attention, ladies and gentlemen.
Thank you so much, Mr. Raymond, for your presentation. I'll be requesting you to share the same with the Secretariat. I can see some of the questions, actually most of the questions in the Q&A chat box have been answered. I think there's just one by Dr. Manana Rogers, who is asking what regional effects are being made by states towards regulation of AI-related activity, as technology is always running ahead of the law. So I don't know which of our panelists wants to answer that question. And if you also have a question, you can raise your hand.
I'll answer from the Kenyan perspective because I'm not too sure about what. From the Kenyan perspective, we have existing piecemeal legislation that cover aspects of data use and especially large-scale data use, but we do not have a single piece of legislation on AI. What we do have was an AI strategy that the government rolled out last year, but the strategy is more on consumer or citizen centric. It's very citizen centric in terms of the benefits and the possibilities that await use of AI for the benefit of the public good or citizen use, but it speaks nothing much about governing, regulating how AI will be deployed and used by public sector or by private sector. So this year, a few weeks ago, there was another attempt in Senate. I believe she's in Senate. Karen Nyamu has tried to forward AI bill that will govern how AI is used. So that one is still up for discussion or is in the floor of the parliament. Looking at it, it's not substantive, doesn't have the substantive clauses governing use and deployment of AI, very general. So I don't know how far it will go. But from sector specific, an institution such as Kenya Bureau Standards has put in place AI parameters when it comes to it offering, because they're the ones who also offer certification on certain products. So they've given parameters for what they would consider an AI tool or an AI product that they can consider for licensing. Unfortunately, this was done with a very small group. of individuals in the sector. So we do not have something that is fully participatory of all the sectors that are deploying AI currently. So looking ahead, I think at this discussion, looking at how we did the data privacy laws, most of the East African countries mirrored the GDPR and customized them nationally. Seeing that the European Union already has its AI Act, I wouldn't be surprised if most of the states decided to borrow from there and then customize it locally. From the AU perspective or African Union perspective, I will not comment on that as well. I'll leave it to my other speakers.
Thank you, Janet. Is there maybe another panelist who wishes to answer that question? Okay, Asimwe Fiona, you had raised your hand. You can ask your question. You can unmute and ask your question. Asimwe Fiona? Okay, we'll move to Juliet Adhiambo, who asks, what happens during assessing and extracting digital evidence? And there is data breach, corruption or destruction of evidence during extractions. Are there rules to prevent this? Is it a legal training or a data science issue? The evidence can be challenging, it can be challenged in court, but it hinders use of AI, which can be positive. Maybe can have panelists react to that.
Kindly reread the question. Thank you.
Juliet is asking, what happens during accessing and extracting digital evidence and there's data breach, corruption, destruction, or evidence during the said extractions? So she's asking if there are any rules to prevent this. Is it a legal training or a data science issue? She says the evidence can be challenged in court, but it hinders the use of AI, which can be positive.
Sounds like a remark and less of a question.
I think the first part was a question on the assessing and the extracting of digital evidence, and then the destruction. Then there's destruction of the said evidence during extraction. I think that was the and so that you ask, or maybe you can clarify whether it was a Juliet, you can unmute. Maybe you ask your question live.
Hello, are you able to hear me?
Yes, we can hear you. Just be a bit audible. You can continue.
The question is, when we never win court, and maybe the expert on the talk, and primarily the evidence abuse from digital devices.
Juliet,
So
we can't hear you. We can't hear you quite well. Maybe. Yes, Juliet.
Yes, you able to hear me? Hello? Hello?
Unfortunately, we can't hear you.
I'm asking, can you?
Faint, you're quite faint.
I don't know, there's a problem with the connection. That's why.
Yes, maybe you can just resend. Was it a question or was it a remark?
It was a question, is that issue of extracting the data from the device, maybe upon which the process, the effort that. So even if it's good evidence, maybe investigation, it should be goes to back up. So
Juliet,
that's
Maybe
I'll
I
have
can
Dusty.
help. Maybe I can
Yes.
help. Juliet was asking
Yes, Jack.
during retrieval of electronic evidence, and there happens to be a corruption, or the evidence is corrupted or it's destroyed when it is being collected in preparation for a court trial. Are there rules or are there legislation or regulations governing the collection of this type of evidence that may be destroyed during collection? How do they go preserving it? About preserving it, and whether it's a data science issue or whether it's a training capacity building issue that can be trained to people to know how to quickly and effectively collect electronic data before it is corrupted or it is destroyed. I have seen a gentleman called Ochieng Oginga on the line. I don't know if you can hear us, Ochieng. Ochieng, are you on the line? I know Ochieng Oginga was one of the lawyers in the team that handled the recent election petition in Kenya, and it involved a lot of amassing and collection of digital data in real time and in very crucial time to be able to file it within timelines prescribed for hearing the election petition. Maybe you can tell us what his experience was in dealing with collecting digital evidence in that scenario. Ochieng?
Yes, I've
Yes.
unmuted him. He can speak. Yes,
Y-
Mr.
Yes, yes, Janet and team, thank you so much. Oh, this has caught me off guard. Sorry. I can clearly hear you. Yeah, now in terms of our experience with the 2022 elections, basically we did not use like any particular specialized AI tools. It was just the way you transmit basically documents online. So basically we're just receiving the forms from our agents from the ground. Basically some were sending through WhatsApp, some were sending through emails. And then in some instances, some were bringing the hard copies to where we were. So we were just using the normal way, like in terms of scanning, then uploading in the portals, or computing or analyzing the same. So at that particular juncture, we were not using any specialized AI tools. Yeah.
Thank you for your input. Thank you, Mr. Ochieng. Jennifer Miano, you had asked to speak. You can unmute. Jennifer? Panelists and for everyone for tuning. We've all learned something from of their presentations with us so that the Secretariat can share them with everyone who tuned in today. Thank you so much, and I'll be seeing you on the next webinar. Enjoy your evening. Thank you.
Thank you, Brenda, and thank you, esteemed panelists, for those wonderful presentations you've both made. We are thrilled and honored that we hosted you today and look forward to having more and more of you. As mentioned by Brenda, we'll be sharing more of those presentations with you, our participants, so that we can take some notes and keep reading through them. At this juncture, while we close our webinar session, I'd like to remind you that on Thursday, we'll be exploring a session on climate justice, and we'll be discussing lessons from East Africa's landmark litigation and courtrooms. So you want to be a part of that. And on behalf of Secretariat, special thanks to you, Janet Osero, Sekanja Kabubeka, Mr. Lawrence Stinga, Mr. Triamu Sima, Geoffrey, and my good friend Raymond Aumpaire. And to you, Brenda, thank you so much. It's been quite an honor. Until we meet again, colleagues, goodbye, stay safe, and enjoy the rest of your week. Bye.
Goodbye. Thank you, Gabriel.
Bye.